Hi, I'm Dan Munley, a partner in the law firm of Munley Cartwright. We've been representing truck accident victims for over 45 years. The first phase in a tractor-trailer case for the client is going to be contacting the office. And when they contact the office, the things that we'll be interested in inquiring to you about are how did the accident happen? Which way did the truck come from? Were you hit from behind? Different types of angles in terms of how you were involved in this accident with the tractor-trailer. Not only is that phone call free and confidential, but at no time during the stages of your truck accident lawsuit will you have to come up with any money. We will only get paid when we win your case. The next phase of a truck accident case is going to be securing the evidence for the client. Once we are in a lawsuit for the client, we come in aggressively. We don't sit back and wait for the evidence to come to us. We go out and get it. And so by that, I mean we have a team that we can drop into place immediately anywhere on the eastern seaboard to start to secure the evidence. And the evidence that we're going to be looking for is going to be skid marks, obviously, on the ground if there are any, points of impact from the tractor-trailer itself and the car on the roadway, and, of course, the tractor-trailer itself. The tractor-trailer itself, has been my experience, in the initial phases or stages of the case, is the main piece of evidence. We want to get inside that tractor-trailer, really climb inside that tractor-trailer and up and down it to see whether or not there was any maintenance issues that led to this accident. Because many, many times it's been our experience, the tractor-trailer's brakes aren't being properly adjusted, their steering wheels aren't being properly maintained. There's a whole host, really, of different maintenance issues in the tractor-trailer litigation phase that we want to get in and see immediately. The next phase of the truck accident case is when we file your lawsuit to preserve the truck's documents. Those documents that we will be interested in preserving are the trip manifest, the log books, the bills of lading, toll receipts, anything that will tell us where that tractor-trailer driver was in the 30 days before he had his accident with you. And the reason that we do that is because we have found, in our experience at the law firm, that these tractor-trailer drivers are driving over the accepted hours by the Federal Motor Carrier Safety Act. And what that means is these people are driving 70, 80, 90 hours in a week, and they're getting tired. So we're finding tired truckers on the road. And these tired truckers are falling asleep behind the wheel of these mammoth vehicles and causing catastrophic injuries to individuals. The discovery phase of your case is really twofold. There's going to be depositions at which you're going to have to testify under oath, and then you're going to be examined by a doctor from the trucking firm. A deposition is a statement under oath. You're going to give a statement about what happened under oath. And really, during the course of a deposition, there's 4 phases. They ask you questions about your background, general information to try to get to know you a little bit. Then they'll ask you what happened in the accident. Then they'll take you through your injuries that resulted from the accident. And then the last phase will be about how you feel now as opposed to what you were like before the accident. And when that time comes, we will take you through those 4 phases before and help you to anticipate how you want to answer those questions. We will take you and show you the deposition room. We will sit with you in the deposition room and prepare you for your deposition. The next thing that will happen to you during the course of this discovery phase is that you will be examined by a doctor from the trucking firm. He's there to represent the trucking company, so we'll be there to represent you. The reason that we take all of the steps that I've been talking to you about here is because when we begin the process of negotiating with the insurance company or the trucking firm, we want to negotiate from a position of strength. We want to be able to dictate to them the terms that we're going to be willing to enter into a discussion with them about. The pros about settling a claim before trial is always that there's finality for the client. If they've lost a loved one, sometimes, many times, the last thing left for them and their closure for that loss is the lawsuit. But if we have to go to trial, it's almost like we have to really bring them back to life in front of the jury so that the jury can get an idea of who this person was before he was taken from us. And then we have to have them die again in front of the family, in front of the jury. Every case that comes to our office, we assume is going to trial. At no time do we ever do anything but assume that that case is going to trial so that when we actually have to go to trial, we are fully prepared to represent you and your family in front of a jury. Once we get to the courtroom, That is where we differentiate ourselves from most law firms. We're a family law firm, but we have been trying lawsuits now for 45 years. When you go to court with a lawyer from Munley, Cartwright, we have already taken every possible step necessary to secure a victory in advance.